It's a real honor to be speaking in this series of presentations and sessions on behalf of the college, and particularly on behalf of the college that the Criminal Justice Department is a part of. I see very many familiar faces here, a lot of criminal justice students who, as you know, being my students, I do tend to be rather philosophical, but I also hope that I'm able to show you that I have a pretty firm grasp of the law as well. So the title of the talk, as you can see, is the International Criminal Court, the Legal Mandate for Prosecuting Human Rights Violations. So according to one of the judges, hearing one of the first International Criminal Court cases on appeals, the law applicable under the Rome Statute must be interpreted as well as applied in accordance with internationally recognized human rights, which is, of course, the theme of our conference. Human rights underpin the statute, every aspect of it, including the exercise of the jurisdiction of the court. Its provisions must be interpreted and, more importantly, applied in accordance with internationally recognized human rights. That's quite a strong statement from a judge in an appellate case. So this talk is about the legal mandate that created and authorizes prosecutions in the International Criminal Court, or the ICC, and how both moral and practical concerns have given international observers reasons to view the court as operating without the kind of transparency required by an international institution of legitimate justice. I'll first give a broad overview of the court's mandate and jurisdictional requirements, and then offer up some observations and criticisms of some of its more controversial provisions and cases. The Rome Statute of the International Criminal Court is the treaty that created the ICC. So when you hear me say the statute or the Rome Statute, it means it's a statute, which is a law, and it was created at a big conference with a bunch of dignitaries and ambassadors and so forth in, where else but Rome. It was signed by 120 states in July of '98 and came into effect 4 years later. The treaty created the ICC, and in effect, it created a new system to deal with the world's most egregious crimes, war crimes, crimes against humanity, and genocide. The court was set up to help prevent serious crimes by ending what's called impunity. If a person has impunity, it means they cannot be punished. So impugn, punish, same root. Impunity means you can't be punished. It was established in response to a decade of human rights abuses in countries such as Rwanda and the former Yugoslavia, with substantial yet not universal, as Dean Twedio mentioned, support. It was intended to act as a court of last resort to step in when nations' legal systems have failed. At the heart of that new system is the idea that first and foremost, the courts at the national level should deal with these cases of serious crimes. The ICC only deals with cases under very limited circumstances. The Rome Statute says in its very first article that the ICC will be complementary to national jurisdiction. There are at least 4 reasons for the complementary system. 1, it protects the accused if they've been prosecuted before national courts already. We call that double jeopardy. 2, it respects national sovereignty and the exercise of criminal jurisdiction. 3, it might promote greater efficiency because the ICC cannot deal with all cases of serious crimes. And 4, it puts the onus on states to do their duty under international and national law to investigate and prosecute alleged serious crimes. That is, it's not just a matter of efficiency, but a matter of law, policy, and also morality. Since its first trial in 2009, it succeeded in convicting several war criminals, even as critics have slammed its slow bureaucracy and its failure to prosecute crimes outside of Africa. While most of Europe, Latin America, and Africa are state parties to the Rome Statute, big gaps remain in the Middle East, North Africa, and Asia in particular. And major powers such as India, China, and the United States remain outside the system. So how do you get jurisdiction? How do you get prosecuted under the Rome Statute? First, an ICC member state refers a situation to the court. This will be discussed in quite a bit of detail later. Number 2, the prosecutor initiating an investigation does it in proprio motu, or on its own accord. There's some Latin for you. And the third one, the UN Security Council refers the situation to the court. This most recently occurred in Libya in 2011. So let's turn to the mandates themselves. The first mandate for the ICC is to prosecute genocide, which is the crime of carrying out certain acts with the intent to destroy in whole or in part a national, ethnic, racial, or religious group. This includes killing members of the group, causing serious bodily or mental harm to members of the group, deliberately inflicting on the group conditions of life calculated to bring about its physical destruction in whole or in part. See how in-depth these are. Imposing measures intended to prevent births within the group, or forcibly transferring children of the group to another group. The second mandate is for war crimes. This crime must be committed in an internal or international conflict, and different rules apply in some of these cases, and it must be connected to the conflict. The kinds of acts prohibited are extensive: murder, torture, rape, pillaging, unnecessary destruction of property, among others. According to the statute, the court shall have jurisdiction in respect of war crimes, in particular when they are committed as part of a plan or policy or as part of a large-scale commission of such crimes. This includes willful killing, torture, or inhuman treatment, such as biological experiments, willfully causing great suffering or serious injury to body or health, or extensive destruction and appropriation of property not justified by military necessity. It also includes compelling a prisoner of war to serve in the forces of a hostile power, or willfully depriving that prisoner of war or other protected persons of the rights of fair and regular trial. It includes the unlawful deportation or transfer or unlawful confinement. Lastly, it prohibits the taking of hostages. Mandate number 3 is crimes against humanity. Crimes against humanity are those that are committed in a widespread or systematic way as part of a plan or policy. They're targeted at civilian populations. They can occur in war and peace, and they include a lot of the same crimes that we've already mentioned: murder, torture, rape, slavery, forced displacement, imprisonment, or other severe deprivation of liberty. That also includes the persecution of identifiable groups or collectivity on political, racial, national, ethnic, cultural, religious, or gender grounds. It also includes, interestingly, as I'll mention in a bit, the crime of apartheid. The fourth mandate since July of this year is waging aggression or waging an aggressive war. The crime of aggression means the planning, preparation, initiation, or execution by a person in a position effectively to exercise control over or to direct the personal military action of a state. It includes the use of the armed forces against other persons or other groups. These acts can include invasion, military occupation, annexation by the use of force, blockade of ports or coasts. Interestingly, and unlike the other provisions and other mandates, only leaders are capable of committing the crimes of aggression. The rest are directed at civilians. Those committed or those convicted under the statute face a maximum of 30 years. A term of life imprisonment is authorized when the extreme gravity of the crime and the individual circumstances of it justifies it. There's no death penalty in the ICC. In addition to imprisonment, the court may order a fine as well as forfeiture of property and other assets that are derived from the crime. In order to punish through the ICC, rights to procedural due process must be respected. Although the purpose of preventing current and future crises by incapacitating individuals may be present in those cases, the goal is purely retributivist. Violators deserve, under the ICC, to be punished. As a result, the ICC suffers from the same circular problems experienced by other criminal justice institutions. By seeking to remedy major violations of rights through both threatened and actual punishment, these institutions tend to neglect to first secure basic human rights against standard threats, which are often the very cause of the major violations the ICC aims to penalize. What then are human rights? Well, according to what we call the natural law tradition, human rights are an extension of natural rights, and human rights are therefore possessed by human beings as such. A human being possesses human rights much in the same way they possess, say, their arms or their ideas. These types of human rights exist regardless of any state or social institutions in the kind of state of nature discussed by Hobbes and Locke. The rights are intrinsic, inalienable possessions, which no other person or state can take away, but they can't violate them. If a human right so described is violated, then the violator is morally culpable, but the bearer still possesses these rights. States play no role in the creation or granting of the rights, but they're morally obligated not to violate them and to ensure that other states do not violate their own citizens' rights. Natural rights, therefore, fall under what we call global justice cosmopolitanism, where the basic idea is that moral rights, duties, and obligations are not and should not be defined nor limited by nationality nor principles of national sovereignty. According to cosmopolitanism, these moral rights and duties ought to be enshrined in international laws, treaties, and statutes like the ICC, which lead eventually to either a global state enforcing a single set of laws or to no state at all. On the other hand, if human rights are simply the types of rights created and protected by the international legal system and society of states, then the types of interests protected by rights can't exist without the existence of the states that are expected to protect them. The rights are something that states create, and without the support of a state to protect them, they are, as theorists as varied as Edmund Burke and Hannah Arendt have argued, merely abstract, unenforceable claims. This conception is variously referred to as the positivist or legalist account of human rights, where the rights are the result of any manner of legislative or adjudicative processes which serve to establish, define, and codify the rights, with the goal of giving rights bearers a formal platform for recognition, protection, and enforcement by way of various statutes, tribunals, and international treaties. The natural rights theorists would presumably agree with these types of statutory rights on the grounds that the positive law is simply codifying, protecting, and serving the natural law. The positivists could similarly hold that the statutes are predicated on natural law, but that, like other theorists, have claimed the states a practical necessity for the protection and the enforcement of these rights. This conception is also positive, formal, and legalistic in the sense that human rights are just the sort of things that the state creates, and then it protects. Without the states or the International Society of States, there's no human rights because, according to this theory, there's no state structure to protect those rights. This conception of human rights has dominated human rights discussions since Hobbes in the 17th century. It was fully codified in international practice with the signing of the UN Charter in 1946. Human rights have been framed in terms of the state as both protector and violator of rights, giving the state an inordinately powerful role in human rights discourse. By positing the state as the primary violator of human rights, this conception is therefore unable to reconcile intervention with actions, if any, that are not within the purview or power of the target state as either the protector or violator of the rights. In other words, if the state is not the violator of human rights, then intervention and the piercing of sovereignty is not justified. It was precisely this understanding of human rights that the ICC is purported to address by holding individuals and not states liable for human rights violations. Because strong and powerful states have created and perpetuated the international statutory framework for rights, then perhaps it's the natural outgrowth of their power to posit themselves as guarantors of rights, and their enemies, the rebels or the dissenters, are the violators. This has certainly been the case when states have asked the ICC for help in prosecuting dissidents in their own country, which brings us back to the ICC's provision for complementarity that I spoke of in the beginning. According to the preamble of the ICC, the International Criminal Court established under the statute shall be complementary to national criminal jurisdictions. It's meant to work with them. This is known as the complementarity requirement. As time has passed, it's become increasingly obvious that this idea is one of the most important, if not the most important, part of the statute. How it's understood, what the ICC does in connection with it, what national authorities do, and what civil society should do have all become important aspects in the debate about justice for victims after very serious crimes have been committed. Complementarity means that a case before the ICC must be admissible. Cases are inadmissible when the case is already being investigated or prosecuted by a state which has jurisdiction over it. Unless the state, and these terms are very important, unless the state is unwilling or unable genuinely to carry out the investigation or prosecution. It's inadmissible if the case has been investigated by a state which has jurisdiction over it and the state has decided not to prosecute the persons concerned, unless the decision resulted from an unwillingness or inability of the state genuinely to prosecute. The person concerned, this is another reason that the ICC would not take jurisdiction. The person concerned has already been tried for conduct which is the subject of the complaint. Again, that's a kind of double jeopardy. Or the case is not of sufficient gravity to justify further action of the court, meaning that the ICC is only supposed to deal with crimes of some level of gravity. It's unclear what that level is. Therefore, cases are admissible when the state cannot or will not prosecute offenders. Under the statute, states are unwilling to prosecute when the proceedings were or are being undertaken, or the national decision was made for the purpose of shielding the persons concerned from criminal responsibility, or when there's been an unjustified delay in the proceedings, which in the circumstances is inconsistent with an intent to bring them to justice. Or third, the proceedings are not being conducted independently or impartially, and they were or are being conducted in a manner which in the circumstances is inconsistent with an intent to bring the person to justice. States then are unable, that's when states are unwilling. States are unable to prosecute when, due to a total or substantial collapse or unavailability of its national judicial system, the state is unable to obtain the accused or the necessary evidence and testimony or otherwise carry out its proceedings. So complementarity is intended to preserve the sovereignty of the state where potential violators are located. This has led to some of the most potent criticisms of the ICC mandate, which again is the permissibility of a state to engage in what is known as self-referral. Much of what follows is taken from the work of Canadian legal scholar and expert on international law, William Shabas, one of the most important critics of the ICC's mandate, particularly in regards to the principle of complementarity. Although the statute clearly indicates that complaints of human rights abuses were contemplated to be filed by the state against another state and not by a state against itself, the early investigations by the ICC were in fact self-referrals by Uganda, the Democratic Republic of the Congo, and the Central African Republic, all of whom were asking for international criminal prosecution of their own rebel groups. Although it's unclear whether those states were unwilling or unable to prosecute those groups, the ICC followed through and found that their intervention into these conflicts was admissible. This self-triggering of international scrutiny is not in itself unusual. The United Nations criminal tribunals for Rwanda, Sierra Leone, and Lebanon have all been created as a result of initiatives from the states on whose territory the crimes were perpetrated, and before whose courts the offenders could normally be prosecuted. By ratifying or acceding to the Rome Statute, states do much the same thing that Rwanda, Sierra Leone, and Lebanon did in consenting to the creation of the relevant institutions. But if the doctrine of self-referral is accepted as it has been, it seems to indicate that state parties to the Rome Statutes have done more than simply consent to the exercise of jurisdiction, and that they have reserved the right to put specific situations before the court for prosecution. When a state's actively engaged in the initiation of the process, there's potential for manipulation. In effect, the state quite predictably uses the international institution to pursue its enemies. When the Special Court for Sierra Leone was being established, President Kabah wrote the United Nations asking that it unleash international justice against the Revolutionary United Front, just as President Museveni did against the Lord's Resistance Army when referring to the situation in Uganda to the ICC. Likewise, Rwanda intended for the ad hoc tribunal to be aimed at the genocidaires of the previous regime, that's French for people who commit genocide, and not at atrocities committed by those now in power in the country. As the first case before the court, Uganda offered the prosecutor what appeared to be a fairly simple prosecution on which to cut its teeth. He could be relatively sure, meaning the prosecutor, of the cooperation of the Ugandan authorities in apprehending those who might be charged. This is because those he was investigating were the enemies of the Ugandan state. President Museveni was in effect asking the ICC prosecutor to help him investigate the rebels within his own country. With respect to the government forces, on the other hand, we're confronted with a classic impunity paradigm, individuals acting on behalf of a state that shelters them from their own courts. But in a domestic justice setting involving ordinary crime, it's unlikely that we would countenance a national prosecutor who ignored clandestine police death squads on the grounds that gangsters were killing more people than the rogue officials. The use of self-referrals, CAHSS continues and concludes, has not created a sense of trust in the legitimacy of the ICC by the many African citizens who believed they were the victims of official police violence. The central conflict of values in the international dispute and conflict today is primarily the conflict between national sovereignty and the universal claim of human rights. And abuses may arise when domestic states grant immunity or amnesty to violators. Due to the growing cosmopolitan nature of international human rights discourse and practice, nearly all of which is dictated by Western or liberal democratic states and theorists, states that are not firmly within those traditions are increasingly the subject of critical surveillance and intervention by the West. Many of these states were created out of the chaos of war and conflict, with little regard for the long-standing traditional borders informally established over the centuries through tribal or ethnic identification. This conflict is particularly true in terms of amnesty. It was decided early on that the ICC would accept no immunities, no amnesties, even for those at the very top. So although the preamble of the Rome Statute claims no impunity, there's nothing in it or in the international criminal law that prohibits the use of amnesty or legal forgiveness for criminal acts. In fact, there's no explicit prohibitions on the use of amnesty in any human rights treaty. And this is probably because states wish to reserve to themselves the right to use this tool when needed. That being said, a state's decision to grant amnesty for the type of crimes covered by the statute is probably one of the most controversial parts of transitional justice. It's difficult to imagine how immunity from prosecution for a crime such as genocide could possibly advance the interests of peace and justice. However, the decision to grant amnesty can be seen as an expression of state sovereignty. If the point of the ICC was to encourage states to prosecute their own serious domestic crimes with a large amount of self-determination, then amnesty seems like a necessary option. Former prosecutor Moreno Ocampo's claim that the success of the ICC will be judged by the absence of international trials, which implies that the states themselves are dealing with the crimes defined by the statute on their own domestically. So fewer international trials means more local justice at home. So here are the questions posed by amnesty. At what point can the ICC prosecutor determine that a grant of amnesty translates to an unwillingness or inability to carry out the prosecution? Question 2, if states decide to grant amnesty and it was done genuinely in the interests of justice, can the ICC pierce the state's sovereignty and overrule the grant and then prosecute? In such a case, if amnesty is granted but the ICC still prosecutes, then sovereignty is violated and it would appear the spirit of the mandate is not heeded. Amnesties, of course, can be very serious failures of justice. However, that does not mean that all grants of amnesty are contrary to the goals of international law. Similar to the use of the negotiated guilty plea in domestic criminal law, amnesty grants attempt to balance retributive punishment with an anticipated future good. Like in standard plea bargaining, a violator might deserve punishment, but holding the key to the development of a future good, such as capturing more higher violators or preventing further civil disorder, a prosecutor might exercise their discretion to offer a plea to a reduced charge or a dismissal altogether. So despite a defendant's manifest criminal liability, the right of the prosecutor to engage in either partial or full-blown bargaining is necessary for the success of large-scale domestic prosecutions that might permit some to be punished less than others, but with the understanding that this is necessary to either get the larger violators or to land a substantial blow to the organization as a whole. Obviously, the same broadly consequentialist paradigm is at work in both plea bargaining and amnesty. We get more good outcomes by failing to fully prosecute all wrongdoers, and some wrongdoers go free as a result. I'm not trying to justify the use of amnesty or plea bargaining, but merely recognizing that the outright prohibition of it would compromise the ability of domestic states to genuinely investigate and prosecute or not its own violators in its own court, which would lead to the violation of domestic sovereignty that the complementarity requirement was designed to prohibit. Let's turn now to human rights and procedural protection for defendants, those who are charged under the ICC. According to Helfer, the corpus of international human rights law does not exist in a single comprehensive treaty, code, or statute. Rather, the rights and freedoms it enshrines are found in a complex web of overlapping global, regional, and specialized agreements, many of which contain identical, related, or even conflicting substantive standards. The ICC recognizes both explicitly and implicitly that persons charged under its mandate have procedural and substantive protections, and that prosecution under the ICC must be consistent with internationally recognized human rights. According to Article 21.3, the application and interpretation of law pursuant to this article must be consistent with internationally recognized human rights. For example, the right to a fair trial is protected under the Universal Declaration of Human Rights. Consequently, the various procedural protections afforded to those charged under the statute are very familiar to our ears. They enjoy, persons charged under the statute enjoy the right to notice of the charges, appointed counsel, the presumption of innocence, a public trial, a translator or interpreter, the right to an appeal, the right against self-incrimination, the right to present defenses, including mental defenses, and if they are convicted, they get credit for time served that they spent awaiting trial. Their guilt must also be proved beyond a reasonable doubt. What the statute lacks, however, are explicit remedies for violations of these rights, as well as a clear understanding of what principles make up the body of internationally recognized human rights. Some degree of ambiguity here is unavoidable in that human rights law is an evolving body of principles, and the open-ended terminology used in the statute, as opposed to a reference to any particular instrument, leaves its meaning equally malleable. The court may be entitled to do so, but in the context of locating quasi-constitutional norms, the court should take care to explain on what basis it adopts the reasons of a European court interpreting a European human rights convention as supportive of a paramount principle applied to a set of cases that have arisen exclusively in Africa, which may have different conceptions of constitutional norms. Other issues, such as the exclusionary rule or rights against search and seizure, also echo Western ideas of a human rights-based conception of human rights. Here's what the statute says about the so-called exclusion of illegally obtained evidence. Wink, wink to my criminal procedure students. Evidence obtained by means of a violation of the statute or internationally recognized human rights shall not be admissible. It's kind of a Fourth Amendment for the ICC. If the violation casts substantial doubt on the reliability of the evidence, we don't have that in the Fourth Amendment, or the admission of the evidence would be antithetical to and would seriously damage the integrity of the proceedings, also very different from our Fourth Amendment. The search and seizure right to privacy is an internationally recognized human right under the Rome Statute. It falls within the court's enumerated sources of applicable law. Arrests of persons or other detentions are seizures and therefore implicate privacy interests as well. To comply fully with its human rights mandate, the court must respect the Rome Statute's remedy of excluding tainted evidence in order to ensure that full human rights are afforded to all persons, including persons charged with the most heinous crimes, such as genocide. Through ensuring human rights to suspects and accused persons, the ICC can set an example to the world that the human rights of all, including suspects and the accused, are indeed sacred. The court's already, in fact, created a version of the Miranda rule. In Prosecutor versus Katanga, the trial chamber refused to admit evidence obtained in a breach of the right to counsel and the right to remain silent by applying a more absolute exclusionary rule that seemed to suggest that any rights breach is antithetical to the proceedings and therefore resulted in exclusion of evidence. Ought to sound familiar to many of you. Due to the growing cosmopolitan nature of international human rights discourse and practice, nearly all of which is dictated by Western liberal democratic states and theorists, states that are not firmly within those traditions are increasingly the subject of this critical surveillance and intervention by the West. Many of these states were created out of the chaos of war and conflict with little regard for the long-standing traditional borders informally established over the centuries. To conclude then, as a young institution, only time will tell whether the International Criminal Court can recognize how these nations deserve not only assistance as they seek justice in one another's nations, but also the sovereign rights necessary to define justice on their own terms. The court must also overcome its prevalent image not as an international court, but as a court dedicated to the prosecution solely of Africans. As you can see from the following graphic, published by a pro-ICC group, the institution has earned its rather insidious nickname as the International Caucasian Court. Thank you very much. And then I think we've got time for questions. Dean? It's so hard to choose from them. Oh, right in front, sir.
Yes, thank you so much for this very important presentation. It's very topical. I know you did not intend to lump African countries together regarding the norms or their norms on international law and so on, or how they perceive the ICC. But clearly, something that came out of your presentation is something that sometimes you hear elsewhere. The African continent and African countries do not have a single perception or abidance by the ICC. From South Africa to Egypt, from Senegal to Sudan, it's very, very different. So I will respectfully suggest that we be more cautious when it comes to that. The second thing which is linked to this is that, as you quite well said at the end of your presentation, this perceived Caucasian entity, at least as far as some Africans are concerned, because most of those who have been either processed or convicted are Africans. But Africans will be very quick in pointing out that it will be easy to find solid arguments to prosecute leaders who are not African and who are still in power and who do terrible things. I mean, if, for instance, children have disappeared under the purview of an African president, people will be blowing horns and asking for the ICC to intervene, right? So, it really is important that whatever we do, and I'm speaking here in my personal capacity, not as a UN staff member, whatever we do on the international stage is a process where we take with us the understanding and the support of those who benefit most, rather than processing it in a way that the population, if you ask anybody on the street in Cairo, in Dakar, in Douala, or in Nairobi today, what is the ICC? They will tell you it is an instrument that is meant to jail African presidents. It is not true, but that's how they perceive it. So perception is important, because justice must be seen and must be perceived as being prosecuted in a very balanced way. And the problem is that the target of this justice, targets are not balanced. And then, when one analyzes the African norms, or the perceived norms that the Africans will apply to just, I think that democracy, whether it is in Africa or in the West, should be on the same norms. There was a human rights charter hundreds of years ago in Africa called the Rome Statute. But Africans never asked Westerners. Most of these countries didn't actually exist. When the Kurukan Sugar was in place under Sundiata Keita and the Mandinka Empire, the United States was not in existence. So Africans need to ask others to abide by their own rules and traditions and customs. So Africans will beg that some indulgence be also applied to them in this case.
Wonderful, thank you very much. I don't have any reply, you said it's beautiful.
So,
Oh, this this would not be consistent with our friendship, Dr. Conte, if you did not respond. So I've been waiting for it.
You want me to take the fifth?
I already waived my right to remain silent. So.
Okay. As a follow-up to his statement, do you ever think that the ICC will investigate human rights violations in the occupied zones by Israel?
There's been talk of it. The one that's probably more likely, which has been on, I think, the tips of the tongues, if that's the right phrase, for the ICC investigators, is Afghanistan. And of course, last month, John Bolton, who is our Secretary of State, is that right?
No.
National
Defendants?
Security Advisor.
National Security Advisor.
Okay. He railed against the ICC for the upteenth time because there's been talk, and I think preliminary investigation going on for the past 15 years, about abuse, human rights abuses by American soldiers in Afghanistan. Afghanistan is a member of the ICC, so Afghanistan can therefore request that an investigation take place against the activities of American soldiers. Israel, I doubt it, and it's far too complex to get into, but Afghanistan, that's a real possibility, I think.
Well, that's the bottom line here now. The bottom line is that we live in a world where the 5 permanent members can shield their allies. And if you are not part of that group, then you go to ICC, the ICC. Consequently, maybe the Africans should withdraw from ICC.
There's been plenty recently. Many African nations have withdrawn for the reasons that I concluded with and that your gentleman friend had mentioned as well. It's lost members, it hasn't been gaining them. Anybody else? No? Oh, hi.
Does the ICC have made investigations about human rights violations against indigenous people, like the Australians Aborigines, for example?
I'm not aware of it. Again, it's primarily been focused in one geographical, yet non-homogeneous population, which is Africa. So the graphic up there is meant to be, whatever you call it, a gallows type humor, meaning these are the statistics that the ICC is kind of bragging about. But there's actually 2 other individuals. The graphic's a little bit old who've been convicted. They're both African. So efforts to punish countries maybe like the United States, United Kingdom, for abuses or genocide against the people located in those geographical areas. I don't think there's even a hint or a whisper of that. Again, this is the criticism of what the ICC has done and the focus of its attention, I think, is very well placed. I'm not sure how much more time we have. We should go, I think, to 2:40. Anybody have a watch?
2:48.
2:48? Oh, I know you made it. Thank you very much.